My name is Jeri Yenne, and I'm the criminal district attorney for Brazoria County, and I also get the opportunity and the honor to be their county attorney, all in one job. Jack of all trades, master of some or none. I have some legitimate unintended consequences concerns that I'd like to point out in this bill, if you'd be willing to listen to them. Certainly it is important for judges to have every tool available to them, but I have some concerns about the way this proposed bill is laid out. And in Brazoria County, we have over 20 law enforcement agencies, 12 jails, all operating at the same time. People bond out of city jails, and they bond out timely on the weekends. Under the terms of this proposed bill, a person could be ready to bond out but not have a risk assessment. So if a judge was going to give somebody a PR bond, they couldn't, because the person, the risk assessor, isn't available, isn't there on a weekend, isn't there when a judge says your bond is $500 or a PR bond. It's mandatory that the risk assessment occur and be considered before a bond, even a PR bond. So that's a pretty big glitch. We have people bonding out on Saturdays and Sundays at city jails that I'll find out about a few days later, but they'd be prevented. Then my other question is, who is a suitable person? The costs to the county are legitimate, and I have some concerns about the hearings that we would talk about. So I would ask that you define a suitable person so that we don't find out later that it has to be an extra person at county.
Senator Whitmore?
What do you mean, who's a suitable person?
Suitable person for the risk assessment. When the bill says the court shall order a personal bond officer or other suitable person, who's the other suitable person? So that somebody doesn't come back and say, you need 10 different staff positions for risk assessors throughout your county.
You know, the Judicial Council is going to help the smaller counties come up with the criteria.
And what I would ask is that that criteria be something that's not, you have to hire 3 or 4 different other people to perform the functions of your risk assessment because you want it to be timely. Thirdly, and very importantly to me, is that setting a bond, it is something sacrosanct, and you want the judiciary to have all the information possible. However, something that's really important that I think is being missed is that this is a judicial decision by a neutral magistrate. I respect separation of powers, state, defense, the judge. And the way this is phrased is that this involves the state and the defense automatically and creates an adversary system at the initial bond setting, which to me is going to require hearings, and that is a huge component. We have 8 justice of the peace precincts, hundreds of people arrested a month, many of them bonding out timely. I literally would not have the staff to go to hearings, and the county would have to appoint counsel on each bail setting, when to me, if you've given the court what you think is an additional tool, a risk assessment, then that's between the judge, who has the sacrosanct and important duty under statute of setting the terms and the amount of bond consistent with the conditions set out by the legislature, and the risk assessment. If you add the state and the defense, you're adding a multitude of hearings at every level, and I'm going to tell you that it's actually going to seriously delay us getting to other cases with people who are in custody waiting jury trials. That will be our reality. When I picked people's brains, they said, oh my goodness, 20 more hours worth of hearings, 10 people. I guess I'll have to reset some trials of people who are waiting jury trials, who are in custody on serious offenses. So that is a huge component. The state and the defense should not be a party to forwarding information to a court separately. It would have to be in a legitimate court setting, because there's no other way.
Madam Chair,
Yes, Senator
you shouldn't be allowed to?
Well, hear me out, Senator, if I might, respectfully. The truth of the matter is the way a court receives information has to be in a legitimate proceeding. I can't just call up a judge and say, hey, judge, do you know this? The defense just can't call up a judge and say, hey, let me tell you about the defense.
It's an ex parte proceeding.
Yes, and so once you include that, you need a proceeding, and that would be a proceeding for every single arrest. And so I would ask...
But stop right there. So you've arrested a person, and
Yes.
you don't want them to have a hearing, a probable cause hearing? I mean, have you been following the Harris County federal court case? And they've actually got video of how the magistrates in the bottom of the Harris County jail decides a bond, it has nothing to do with the risk assessment. It's a scale sit down by the county and district judges. One magistrate tells a low marijuana offender, if you say yeah to me again, I'm going to double your bond. Guess what? The young lady said yeah again, and her bond was doubled. That is the system we're trying to correct. It needs to be based on will she appear back in court and what's the risk to the community, not whether she's using proper manners with the judge.
No disagreement with that, Senator. What I have a disagreement is...
And you mentioned the cost. Of course we're sensitive to the cost. But surely you don't want to sit there and say we need to keep someone locked up. No. One, because they can't afford a bond, because you don't want the cost of having a proper hearing.
No, that's not what I'm saying.
It sounded like
okay, it's not what I'm saying, Senator. What I'm saying is when you forward information to a court, the state and the defense, it needs to be in a proceeding with both of them present for the court. So will there be additional substantial cost if you add the state and the defense? For what a judge... I'm just saying legitimately. So, and that will be a significant amount of hearings in our county on a regular basis, including appointment of counsel. But what that means is that we will back up our criminal justice system on other cases.
But it's so much more fair and just.
Oh, I want fair and just. I want.
But you're worried about a timing to give this person their fair hearing, because it's going to maybe make you work harder or slow down your docket.
Not at all.
That's the way it sounds.
No, I truly believe that when you've gone from a judicial system under 1715, and many people in here have been district judges before, it's the court's determination to determine the amount of bail, and you're giving them an extra tool, the risk assessment.
Yeah.
But now, under your statute, you would be adding the state and the defense to the initial bond determination, not any subsequent hearings, and that is a sea change. So the effect of that would be that there would have to be multiple additional parties, state and defense counsel, at every single arrest in Brazoria County and in other
arrest, the proper cause here. You
well,
said not at the arrest. It's not requiring anybody to be at the arrest.
Okay, and maybe I'm
that's
confused.
what you said. So I'm trying to take you literally. You just said it's going to require the state
requiring
and
of
defense
setting
to be
bond.
at all the arrests. I mean, I'm sitting here as mind-boggling. What are you talking about? At the
Okay.
arrest? It's
At
at
the
the probable cause hearing when bond is being set.
When bond is set by the justice of the peace in our county.
Sure.
That's what would be required at all times. And so is that going to have an impact if the state...
We sure hope so.
Well, okay.
We hope that people will be viewed in a risk assessment that judges across the state are not doing, because you and I know some bad gangsters get out because they can post that very expensive bond, and then you got a low-level offender that can't come up with a bond is being kept. And that's as simple as I can say. We're tied up in a federal court. We like to in Texas do things before the federal government gets involved. And I would strongly suggest, and even ask your opinion, don't you think if we don't fix it, that the federal judge is going to do it in Houston for us, and we probably won't like that outcome because we lost control.
I believe that we can make some improvements, but I do have some legitimate concerns, and if I might express some of those legitimate concerns.
Because I think we're all in agreement that there needs to be reform, but I think it's very important that that we follow through with those who are going to have to work in the trenches, make sure that we implement the reform that the council is requesting, that Senator Whitmire is promoting, but that we understand exactly how it's going to affect, Brazoria County, which I represent partially with other senators, but and so we just
And Madam Chair, just for the record, we've worked not only the council but my office and the House sponsor have worked regularly with the DAs as late as last night. They have a major input in this piece of legislation.
Well, but they still have some concerns. At least one of my DAs does. So with all due respect.
And we do have some concerns, and some of those also are at additional hearings. If there was subpoenaing of victims and witnesses to hearings, particularly on the pretrial detention without bond. So I would ask you to consider a few things. That subpoenaing of victims and witnesses and law enforcement officers for increased hearings on pretrial detention could have unintended consequence. While it looks very good, and in many respects, many respects will have some unintended consequences, and those are that a child victim or witness could be subpoenaed, a sex assault victim, an officer to a hearing, all for what the courts, and I believe in the risk assessment that it is important for the court to be able to have additional information, but it will require additional hearings with victims and witnesses, and I do not believe that victims and witnesses need to be re-traumatized, particularly under a clear and convincing standard. I must express that for the record. And I have a couple other concerns about your list of violent offenses, if I might. All offenses are not alike. All offenders are not alike, all cases. And that is why each case does need to be individually looked at for justice. And that extra risk assessment
One comment, Madam Chair.
Sure.
But you know they're not being now.
Okay.
They're not. There's just a schedule. And depending on the offense, that's the bond that is set.
And if I might, Senator,
And so what you're proposing,
not in Brazoria County, there's no schedule.
no,
The judges do.
you may run a perfect system. We're trying to fix the broken parts.
And I want the broken parts fixed also. But there are victim and witness concerns to this. And if you look at your list on violent offenses, there are some nightmare scenarios that could occur. We have JPs who are wonderful JPs, but they're not attorneys. And so when you get to the point where you're denying bail at initial hearing, that's a serious matter. It puts an extra burden on the state for clear and convincing. It requires victim and witnesses and law enforcement officers. And it additionally...
You know that's discretionary on the judge. They may deny
Yes,
bond.
but when you have a couple hundred arrests, a judge could deny bond on a regular basis, depending on who your judges are, and that's the reality. So I'm simply expressing some legitimate day-to-day concerns, which could honestly affect delaying other people getting their day in court who are incarcerated. That's all.
Thank you. Thank you. Is there any other questions of Ms. Yenne? Thank you very much for your input.
Thank you.
All right, Ed, and I'm going to make a stab at this. Shut up.